Well, good afternoon, everyone. I'm Deborah Healey, co-director of the Herbert Smith Freehills China International Business and Economic Law Centre and professor at UNSW Law and Justice. And I'm delighted to welcome you to the second webinar of CBOR's 2021 Global Network Conference Series. At the outset, I begin by acknowledging the traditional custodians of the lands on which we meet today, the Bedigal and Gadigal people, for where UNSW stands, and I pay my respects to the elders past, present and emerging. I would also like to extend that respect to other Aboriginal and Torres Strait Islanders who are present here today. This session will examine two critical areas which are products of the all-pervasive digital environment in which we live and work. It continues to have maximum impact on our global and local commercial and business transactions. We'll focus on two important areas arising. The first is the difficult area of merger assessment in the digital space. How is assessment to be done in this dynamic environment with so many outcomes which are uncertain to consider? Dr. Rhonda Smith will present on this topic. The second area we'll talk about is the development and rise of central bank digital currency and its impact on domestic and global transactions and its implications for competition. The basic question being, of course, how to ensure that consumers and economies are better off. I will speak on CBDC and competition issues generally, and Professor Liyang of Shanghai Jiao Tong University will give the example of China. Each of the speakers will speak and we'll take questions at the end. So I will hand you over to Dr. Rhonda Smith, who is a senior lecturer in the Faculty of Economics at the University of Melbourne. She's very well published and experienced, and she is a former member of the Australian Competition and Consumer Commission. She's a former commissioner. So I will hand over to Rhonda now.
Thank you for inviting me to speak. In this short presentation, I will first of all touch on why mergers are so significant for competition law, then identify some of the problems being encountered in relation to merger control, and finally make some suggestions for improving merger control. Perhaps the first question to ask is why are competition authorities so concerned about mergers? Why are they special? There are many reasons for mergers. Often it will be to increase efficiency, and rarely will it be to decrease competition. A merger may alter the structure of the market, resulting in it being less competitive in future. This has two consequences. Firstly, it is usually very difficult to undo a merger once it's occurred, that is, to unscramble the egg. And secondly, anti-competitive conduct will need to be addressed under other provisions of the competition law. Only a small proportion of the many mergers that occur attract serious attention from competition authorities, but those that do tend to involve high-profile companies and so attract considerable attention from the media and sometimes from politicians. So what's new? What is it about mergers today that is giving rise to unease and concern that mergers will substantially lessen competition and they're being allowed to occur? One problem is that major platform businesses such as Google, Facebook and so on are acquiring small startups. However, because these firms have almost no market share at the time of the acquisition and have an uncertain future, they would be unlikely to be blocked by current merger provisions. These types of mergers have been described as killer acquisitions or as creeping acquisitions. They allow successive acquisitions, enabling a build-up of market share. An example would be the acquisition of WhatsApp and Instagram by Facebook. What is the competition concern? Very briefly, one concern is the removal of an effective future competitor. A second is the replacement of the acquirer's product by the product of the acquired firm, thereby reducing innovation and associated with it dynamic efficiency, which is a basis for competition. Thirdly, there may be an alternative buyer that would not substantially lessen competition. Instead, it might become a more effective competitor as a consequence of the acquisition. Do we have any solutions? Well, part of the problem is the mandatory notification thresholds, because of course these very small acquisitions fall below it. So could the mandatory notification thresholds be altered in a way that offered a solution? Perhaps the threshold could be based not on the market shares combined, but rather on the market share of the acquirer, or perhaps the revenue of the acquirer. Another alternative would be to say that all platform businesses must notify if they are proposing to acquire another business. The second major problem for merger enforcement today is the very much more dynamic nature of the markets involved. The Google-Fitbit merger illustrates this. Fitbit manufactures and supplies wrist-worn wearable devices and other related products. The ACCC described the prospects for these. It stated, "Wearables are an emerging channel or platform through which many services may be offered and data collected." The Commission concluded that wearables are likely to be capable of many of the core functions currently undertaken by smartphones, shades of Maxwell Smart. But what are those services? How will the data be used? At this point in time, we simply don't know the answer to those questions. Although much has been made of this uncertainty in relation to platforms, it is not confined to platforms. Take pharmaceuticals, for example. A product developed for one purpose may fail commercially in that respect, but then become a major treatment for some other medical condition. The search for drugs to treat COVID-19 might provide an example. In other areas, uncertainty arises from changes in business models, platforms being the most obvious example. But other examples are to be found in the sharing economy. With this uncertainty about the nature of products and business structures, how can we determine the relative market or markets within which to assess the competition effects of a merger? Can we even identify the focal product adequately? How can we decide what might be a close substitute product, especially when it may be currently in an unrelated product area? When it comes to the competition analysis, concern has been expressed that it is very difficult to describe the counterfactual situation in future absent the merger. But it is also difficult to describe the future with the merger, the factual. It is also uncertain. Given this, in circumstances where mergers are adjudicated by courts, how can the Competition Authority provide sufficient information about the uncertain future to satisfy the rules of evidence? There are other problems associated with merger control, such as strategic behaviour. An example which has received quite a bit of attention in Europe is gun jumping, completing the merger before the Competition Authority has completed its investigation or made a decision. There is also some evidence of parties gaming the system, for example by notifying a merger very close to completion, but nevertheless expecting a decision from the Competition Authority. There isn't time to discuss these issues now, but it is at least worth flagging them. Multinational mergers are by no means new. but they have increased in significance with globalisation. They create difficulties for competition authorities. First of all, in obtaining the necessary information as a basis for assessing the merger. Secondly, due to the need to understand the effects of the merger in their own jurisdiction, but where those effects may be influenced by conditions in other jurisdictions. Multinational mergers can create enforcement problems. If a competition authority or a court in one jurisdiction rules that a merger is anti-competitive, what happens if it is ruled not to be an SLC in another jurisdiction? It is interesting to note that when the ACCC took court action in relation to Google's acquisition of Fitbit, the court stayed proceedings until the matter was decided in the US. To generalise the statement made by Rod Sims, the chair of the ACCC, is a particular country to have its merger policy subject to the findings of courts in other jurisdictions. Multinational mergers don't only create problems for competition authorities, they also create problems for the parties. Different jurisdictions require different information to assess a merger. They may have slightly different interpretations of the law, slightly different conditions attached in assessing mergers. What happens to the business case for a merger when it is approved in one jurisdiction but disallowed in another? Or when different undertakings are required to allow the merger to proceed? The problems associated with multinational mergers are being addressed to some extent. For example, by formal and informal arrangements or engagement between competition authorities around the world. Through organisations such as the OECD and the ICN, but also by bilateral arrangements between competition authorities. To this point, I've made some general suggestions about how to address some of the problems that have been identified. Let's now dig a little deeper into how we might deal with these problems. To begin with, it's worth remembering that merger policy is part of a broader competition policy, and at present there is considerable debate about what its objective should be. Should it be to protect the competitive process, as has been the traditional view, or should it be to ensure efficient outcomes from markets, or perhaps to maximise consumer surplus, or maybe total surplus, or to ensure equity or fairness? This is not the place to debate these issues. However, if you would like to know more about this, you might like to look at the OECD Roundtable for December 2020. Once competition law is in place, there's a tendency to add non-competition issues to its role. For example, protection of small business. However, as more objectives are added, there is a risk that the original objective, in this case the protection and promotion of competition, will be compromised. From the perspective of mergers, one issue is the role that efficiency claims can or should play in assessing mergers. In most jurisdictions, the test is a substantial-less competition test, not an efficiencies test. But competition is valued because it increases efficiency. In some jurisdictions, a merger that is efficiency enhancing is treated as per se legal. The concern about this is that the empirical evidence suggests that frequently these claimed efficiencies are never achieved. Clearly, efficiency gains are important, so perhaps a better way of looking at these is to first of all consider whether the efficiencies are likely to be pro-competitive, and then these can be balanced against the anti-competitive effects of the merger. Alternatively, an exemption might be provided from the prohibition on mergers that substantially lessen competition if the efficiencies are likely to result in a net public benefit. In dynamic and emerging markets, market participants, not the competition authorities, will have the best understanding of the impact of the proposed merger. Reports such as the US Judiciary Committee report on competition in digital markets, the European Commission's competition policy for the digital era, and the Stigler Committee on Digital Platforms' final report have recommended reversing the onus of proof for acquisitions by digital platforms to reflect this. By way of contrast, the Furman Committee in the UK did not recommend reversal of onus of proof, although one of its members subsequently suggested that she would consider changing her opinion about this. However, if parties need to satisfy the competition authority that their merger will not substantially lessen competition, effectively the onus is already with the parties. Of course, this is not the case if the competition authority is not empowered to make administrative decisions in relation to mergers, instead needing to seek a decision from the court, or where an administrative decision is appealed to the court. In these circumstances, reversing the onus may prove helpful. As explained earlier, there are real difficulties in addressing mergers which are digital and/or occur in dynamic markets. This results from uncertainty about the nature of the product supply, other products that might be substitutes for it, and what the market will look like in the future. This creates significant evidentiary problems where the merger is assessed by a court, either initially or on appeal. Courts are governed by rules of evidence, and the more dynamic the market, the more speculative opinions are about the future. Given this, it may be worth considering moving away from decision-making by courts to having a competition tribunal make decisions. Where currently decisions are made by the court, the tribunal would replace it. Appeals from the tribunal would go to the court, but only on points of law. Where administrative decisions are currently made by the competition authority, appeals from these decisions would go to the competition tribunal, as occurs in the UK at present. Are there disadvantages or problems that would result from such a change? Well, one disadvantage might be considered to be the timing. Is this going to blow out the timelines? Well, not necessarily. Strict limits can be imposed on a tribunal for making decisions. In addition, there may well be a shortening of the decision-making chain. That is, the number of appeals that can be entered into and which extend that decision-making time significantly may be much more limited. Nevertheless, the courts will continue to have a role. For example, in issuing injunctions, perhaps where gun jumping has occurred, and also in handing down penalties where applicable. But what would be the benefits of such a change? The tribunal should not be bound by the rules of evidence. Of course, this doesn't mean that they would accept purely speculative opinions, but it would be a lower threshold. The composition of the tribunal would also be advantageous, not just a judge, but an economist and possibly a business person, which would provide more understanding of the economic and commercial reasons and issues associated with the merger, and enable the use of more appropriate but more complex models. I hope I've provided you with something to think about and to discuss. Thank you for your attention.
Well, thank you very much, Rhonda, for that interesting and informative discussion of the problems which have exacerbated traditional merger analysis issues where digital platforms, etc., are involved. And we will revert to you for questions at the end of the three speakers, as previously discussed. So I'm the second speaker in the panel, and my topic today is CBDCs and competition, a different ball game. and I'm a professor at UNSW Law and Justice and a director of the China International Business and Economic Law Centre. And I research primarily in competition law and policy, both in Australia and in Asia, and I've engaged in significant research in relation to ASEAN countries and China. And I am also, I've consulted for UNCTAD, OECD and ASEAN. So I've looked at a whole range of competition areas in a whole lot of jurisdictions. I've already referred in my introduction generally to the rapid growth of digitisation, which we're all aware of. And due to the current state of central bank digital currency development, it's really only possible to talk about competition in a big picture sense in this presentation, and that's what I'll do. So what we've got is we've got a series of jurisdictions that are running small or pilot projects, although China is running one which is not that small. Other jurisdictions are working on how their version of central bank digital currency would look. So once again, discussions about CBDCs and competition involve much forward gazing. And it's important to note that conversations about competition law and the impact of the digital environment are occurring worldwide, and Rhonda alluded to this a little, in the face of the rising market power of digital platforms. And there's substantial debate on whether traditional competition laws are fit for purpose in the digital context. So next slide, please. What I'll touch on in this session are the issues outlined here. Very basic introduction to CBDCs, talk about the motivations for their introduction, talk about some competition issues, and examine briefly the role of data and the role of privacy in this matrix. Talk about who the potential competitors might be in a CBDC environment, and talk very briefly about international currency competition, and then draw some conclusions. Thank you. So if you have a look at the top here, you'll see that Christine Lagarde at the IMF has suggested that if privately issued virtual currencies remain risky and unstable, citizens may call on central banks to provide digital forms of legal tender. And that's what's being looked at now. So there's a definition here. CBDCs are a form of digital money denominated in the national unit of account, which is a direct liability of the central bank. And that's the difference between CBDCs and other virtual currencies. So basically, CBDCs are a blockchain-based virtual currency issued by the central bank. Other digital money, as I've called it, are things like Bitcoin, which is really decentralised digital currency with no intermediary and not government-backed, so there's nothing to guarantee the system. And Libra, which is really a special category which has some potential to enhance efficiency, but may generate risks to financial stability if it's adopted on a grand scale. It's different from Bitcoin in that it's pegged to a more stable asset, such as US dollars. And then there are other global stable coins, which again may disrupt the financial services markets. And all of these other areas are risky because they're outside of the government's ability to control monetary policy. And the question is, will they disrupt economies? Will they disrupt the monetary system within a country or internationally? Also, I haven't put on this list, big techs also are into financial services, as you know, and there's Alipay, there's WeChat Pay in China. So really they're third-party payment systems which are not really part of government, although government may regulate them. So importantly, though, all of these sorts of things should be viewed against the background of the role of the financial sector in providing efficient ways for households and businesses to make and receive payments. And the investigations that are going on envisage both wholesale and retail level CBDCs, and they create different issues. And the question is, what is the role for the private sector in relation to each? Thank you. So all of the discussions here are against that background role of central banks maintaining the safety and stability of the financial system. The Bank of International Settlements has identified key advantages of central bank digital currency here as settlement finality, liquidity and integrity, and efficiency, convenience and safety of the payment system. So all those who are investigating this accept that they should be designed with the public interest in mind, using things like open platform systems to level the competitive playing field, to make them conducive to innovation. And of course, the benefits that arise from the introduction of central bank digital currency will depend on the competitive structure of the underlying payment system and things like data governance arrangements. So a key question is, what should the balance be between government and the private sector in this CBDC architecture? But they will create opportunities for banks and other financial services providers. So one of my main questions in all of this examination of CBDCs is where retail CBDCs will find their niche. Why will CBDCs be attractive to consumers, more attractive than other financial payment systems than we already have? And if banks are involved, what's in it for the banks? Particularly if it detracts from their existing financial products. If it's to be cheap and efficient, as a lot of the proponents suggest, who will pay for it? Who will pay the banks? Because the banks are not going to be happy about it being cheaper and more efficient than their existing products. So I think that's a question which needs to be considered. Next, please. So as I've already said, it's hard to be too specific here because policy and regulatory development is at an initial stage in most jurisdictions. But competition must be considered against those developing CBD frameworks. And competition should be imposed against a robust and unambiguous legal framework in all other respects. Crucial decisions need to be made to foster competition in the context of the creation of a public good, which is the rationale of central banks, as we've already said. And I've already noted it's really important that open systems be emphasised, and that has been emphasised in most of the research that's already been done. In that regard, I think it's important to recall the importance of competition impact assessment as part of regulatory development and as part of a general regulatory impact assessment, because this is the time to ensure that the competition settings are appropriate to create a level playing field. There needs to be alignment with the consideration of competition issues. Sorry, there is alignment in all of this with the current considerations of competition issues in relation to digital platforms, because a lot of the issues are the same, particularly given the digital platforms too are involved in many third-party payment systems. Next, please. So what are the motivations for developing CBDCs? Well, most often they're a combination of factors such as purported efficiency, financial inclusion, maintaining the relevance in currency in the face of declining use of hard currency, maintaining control over monetary policy by governments, and also countering other digital options such as Libra and global stablecoins, who I think would be the most likely competitors. I don't know that Bitcoin is really a full-fledged competitor would be a full-fledged competitor to a CBDC. You need to consider whether these options are true competitors of CBDC. And interestingly, the Bank of International Settlement has made this important comment on technology, saying the same technology which can encourage a virtuous circle of greater access, lower costs and better services might equally induce a vicious circle of data silos, market power and anti-competitive practices. And open platforms are most conducive to a virtuous circle. So in relation to all of this too, competition has to be assessed against the background of the traditionally high barriers to entry in the financial payment area. And as I've already said, the current ongoing competition law debates about the suitability of the competition law framework to counter the market power of digital platforms. And as Rhonda said, when you're looking at mergers, it's far better to stop the merger at the outset than have to unscramble the eggs later by using other provisions of the competition law. I would draw an analogy with that and say it's far more practical to set up an appropriate architecture at the outset to ensure that there is competition rather than have to address an unsuitable architecture with competition law at a later date. Next, please. Two critical issues that are often mentioned in this argument are the large volumes, or mentioned in the arguments about CBDCs and whether they should be implemented, are arguments about the large volume of personal data collected, which raises issues of data governance, consumer protection and competition. And data is, as you know, a big issue in competition because it may confer market power and competitive advantage on the holder, depending on what the holder is allowed to do with that data. And in a CBDC context, for example, it may enhance network effect, raising barriers to entry for potential competitors and existing competitors. And as we know from cases which have been, or investigations conducted overseas, holders of data do not always use the data in ways which consumers would agree to if they were asked. Strict protocols for digital identification need to be in place to ensure privacy and that information is not shared outside the scope of any privacy regulations and permissions. On the other hand, CBDC has the advantage that being government-backed, it will assist in compliance with anti-money laundering regulations and also in the policing of tax avoidance in ways which other systems like Bitcoin, Libra and global stablecoins cannot, because they're not tied to government in any way. Next. So turning our attention to competition on the ground in a CBDC environment, who will be the competitors? Will CBDCs compete with cash? Will CBDCs compete with other cryptocurrencies such as Bitcoin, Libra, global stablecoins? How will CBDCs compete with the existing products of commercial banks? And I've already raised that as an issue. And how will it affect other potential new initiatives in financial transactions and competition in that field generally? So as I've said, ultimately, in my view, the question becomes why use CBDCs at wholesale or retail level? What is their competitive advantage? Who are they really competing against? Because their close competitors will determine markets. And at a most basic bottom line is what's going to motivate people to use CBDCs? The last point there is CBDCs may compete with other CBDCs internationally denominated in different currencies. So there are potential currency wars there. So I have only got a couple more slides. Next, please. I've raised some questions here about competition issues which might occur, just putting what I know about CBDCs into a competition law framework, and these are sort of common problem areas. I think abuse of dominance is really important. So will powerful corporations obtain exclusive rights to prepare particular areas of the framework with the ability to exclude potential competitors and innovators? How will network effects play out? Will holding data increase the market power of individual organisations? And will entrenchment of market power exacerbate the high costs of payment services? And you can have a look at the others for yourself because I'm being told I'm running out of time. There are also, next one please. There are also international currency issues in relation to particularly RMB internationalisation and whether China is currently saying it's going to be a domestic CBDC, but if it is internationalised, will there be, for example, the creation of new currency areas either in China and its close contacts or in other areas, maybe the EU, maybe the West African economic area? Those are issues which might be considered. Next slide, please. So really, I've got my conclusions here. Jurisdictions are have widely differing motivations for implementing CBDCs. The developing jurisdictions see the benefits for financial inclusion and they seem to be keener. Developed jurisdictions with robust financial systems appear to be a little more cautious. And despite the fact that some jurisdictions are piloting CBDCs, there appears to be a general view that this should be implemented slowly and a common approach taken to the extent possible. The benefits and downsides, however, need to be considered carefully in each jurisdiction. The regulatory caution provides the opportunity to carefully consider the complications, the competition implications of CBDC architecture and regulatory settings to create an optimum environment for competition going forward. And competition itself will be essential to efficient use of the system. Finally, jurisdictions such as China appear to be powering ahead, and my guess is that if digital RMB goes international, other jurisdictions may follow more quickly. So that's the end of my presentation. Thank you for listening, and we will now move on to the next presentation, which is a presentation of, Professor Liyang, who is Professor of Competition Law at Kogon Law School, Shanghai Jiao Tong University. He obtained his PhD in law from Catholic University in Leuven. His research interests cover a variety of legal domains such as competition law, internet regulation, telecom regulation, and the economic analysis of law, and he has published 10 books and more than 60 academic articles. The topic of his presentation today is competition regulation of digital renminbi. And I give you the floor, Professor.
Okay, it's very nice to be invited to speak here. I have extended a lot of webinars organized by CBDC. The topics are all very interesting. It's always a pleasure to be here. And my presentation will follow Deborah's presentation, according to her presentation, there are a lot of interesting issues relating to competition between digital currency with other competitors. So I will respond to some questions she raised in her presentation with a focus on the digital currency in China, digital RMB. My presentation is comprised of 5 parts. So I will first give a very brief introduction to digital RMB in China. Then I will describe the competition situation here. Afterwards, I will compare digital RMB respectively with deposit and payment solutions. In the end, I will submit my proposals. So digital RMB, the official name is Digital Currency Electronic Payment, DCEP. According to this name, we can know the 2 major functions of digital RMB is digital currency and secondly, electronic payment. Digital RMB has not really come to China yet. However, we are now in a period of experimental issuance. The experimental issuance started in May 2020, last year, in the middle of the pandemic virus. Afterwards, the government give red envelopes of digital RMB in a couple of cities, in Shenzhen, in Suzhou, and also recently in Shanghai. My wife received DCP red envelope a couple of days ago. So how does digital RMB look like? It's basically an app installed in your smartphone. By this app, you open a bank account in some banks that is cooperating with the central bank in China. Then you can exchange your physical RMB into digital RMB. So afterwards, so there is like a QR code from this app. You can have it scanned by some machine, then you can use it anywhere as long as they accept. Well, according to law, all the places must accept digital RMB, but I suppose this rule must have some limits because not every shop has such equipment. So put a simple word, there are 3 major characteristics of digital RMB. So first is legal tender, has the exactly same legal effect as physical RMB. And secondly, the central bank implements a controllable anonymous authentication scheme, which means that it's not using the same technology as Bitcoin, namely distributed ledger technology. It's centralized issuance, it's not decentralized currency. And the last one is very important, dual issuance mechanism. So we cannot get digital RMB directly from the central bank, but indirectly from banks. So banks are still intermediary in the financial system, even in the case of digital RMB. I'll come back to this point later. So my research will focus on the commercial barriers faced by digital RMB and propose some solutions. So it's not an article about financial law, but an article about competition law. I will examine the relationship of digital RMB with some competitive products, and then to assess the advantages and disadvantages of digital RMB to see, well, if in case of disadvantages, how can we improve digital RMB? So at the first step, I collect like 3 possible competing products with digital RMB, which are virtual currency, digitalized physical RMB, other payment solutions. I will explain them later. So virtual currency, I suppose I don't need to define this term. Deborah already came across this point. So we have crypto type cryptocurrency like Bitcoin. We also have a stable currency like Libra. Its current name is DIM. We also have a stable currency like USDT. But virtual currencies are not recognized as the central bank as a legal tender in China. All the banks and financial institutions are required not to accept virtual currencies as payment in China. So virtual currencies might be used in China in black markets. So in those circumstances, it might compete against digital RMB de facto. However, according to law, they are not competitors. So just my conclusion is that I will exclude virtual currency from my research. And the second one is digitized physical RMB. So we have digital RMB, and what is digitized RMB? So everybody owns a lot of physical currency, but we seldom use it. I can't remember when was the last time I used physical RMB, probably like half a year or even more than a year ago. So where does all the money go? Actually, there are two ways we store those physical RMB. The first one is called central bank reserve, and the second one is commercial bank deposit. So let's first look at central bank reserve. Reserves refers to the amount of money banks must store in central banks when they receive deposit from consumers as a safety measure for the deposit. So when banks store RMBs in central banks, they will receive some digital numbers. Those numbers are stored in the ledger of the central bank. So reserves, when they store those physical money in central banks, those money becomes digitized, and they can be used by financial institutions for the purpose of interbank settlement. Some people call reserves as wholesale digital RMB. However, only financial institute can use reserves. So the only clients for reserves are financial institutions. Then let's look at digital RMB. Digital RMB is also digitized currency. However, they serve only financial consumers. So people call it retail digital RMB. Retail digital RMB cannot be used by financial institutes for interbank settlements. So we can see from here, although the two might have some substitution, they do not have demand side substitution. You know, it's a classical competition term, demand side substitution and the supply substitution. We use them to define relevant markets. Since reserves and digital RMBs do not have demand side substitution, they are not competitors or not on the same relevant market. So I also exclude reserves from my research. And secondly, deposit. So what is the nature of deposit? Deposit are actually private issued currencies. When we store money in banks, we actually treat our legal tender with some numbers. Numbers that is that's actually promised by banks. They will pay back to us. But there is a danger that we might not get the money back if banks are broken. So deposits in nature are different from legal tenders. However, in the current society, we have many legal measures to ensure bank will in the end pay us back. So in practice, deposits are equal to legal tender, at least from the perspective of consumers. And since deposits are also considered as consumers as legal tender or quasi-legal tender, so on the demand side, consumers would not consider deposit and digital RMB are different. So when they buy something, I mean, the other party would not care whether it's deposit from bank or digital RMB. And secondly, from the supply side, that's also not cared by financial institutions whether consumers store digital RMB or digital RMB in the banks. So both from demand side and the supply side, they're substitutable. They're on the same run market. And last one is digital RMB vis-a-vis payment solutions. One of the major functions of digital RMB is to make payments. So they must be competing against other payment solutions. So well, when we pay something, I mean, for consumers, we have to check which one is more convenient. And digital RMB, and also we have a deposit. We also have third-party payments. So for consumers, I mean, I just showed the picture in the previous slides. That makes digital RMB not significantly different from other type of payment solutions. That's also the same for financial institutes. They might not care whether it is digital RMB or other type of payment solutions. So the conclusion is still they are on the same run market. So after such an investigation, my conclusion is that major competitor for digital RMB is first commercial bank deposit and secondly payment solutions. So subsequently, I will identify the advantage and disadvantage of digital RMB respectively with deposit and payment solutions. So first, let's look at the relationship between digital RMB and the deposit. So the purpose of bank to accept deposit is to lend. So when they receive deposits, kind of cost for banks, and they must make some profits by lending those deposits to other people. When lending the deposit to other persons, there is a constraint for commercial banks, which is the reserve. I just explained the reserve before. So in China, the reserve issue is in average 9.4%. Which means that the maximum capacity of bank to lend money is 10 times of their deposit. However, in the case of digital RMB, it is required by the central bank that the reserve ratio is 100%. So when commercial bank receive $1 digital RMB from consumers, they must reserve $1 to the central banks. So in this case, the financial institution would completely lose lending capacity. Then the issue comes out. So if in the future, digital RMB is fully commercialized, banks also have to promote digital RMB, which means that the lending capacity for banks would be lowered. And it also means that the lending rate for consumers must be increased. So in this case, would you think financial institution will promote digital RMB in the same way as deposit? I would seriously doubt that, because that would decrease the lending capacity of banks. This issue is called narrow banking problem. And then we look at the relation between digital RMB and payment solutions. So in China, we have a number of payment solutions available on the market. There are some traditional tools. There are also innovative electronic tools. So traditional tool, I don't think I need to explain those terms. But if you do not understand, I may answer those. I may explain the terms in the Q&A part. So traditional tools like counter payments, you go to the bank to make payment, bank card payment like credit card, negotiable instruments like checks, and the electronic tools like internet banks and mobile payment. The difference between internet bank and mobile payment is that they use on different devices. Internet bank used only for computers, mobile payment used for smartphones. The technology behind the two types of payment solutions are similar. However, mobile payments give people some advantage in mobility, and also when we pay with mobile payment, we can scan QR code. That is not the function that can be achieved by internet bank. And then third-party payment like Alipay, like WeChat Pay, like PayPal, they are not offered by banks but by non-bank institutions. So third-party payment. And let's look at this table that shows the amount of transfers for different types of payment services. For the time being, I would like to get your attention on the right side, so we can see that the Chinese commercial banks put daily limits on different payment solutions. So as we can see from here, counter services and bank card payment receive no daily limits at all. Online banking payment receive 1 million daily payment limits, and mobile payments and third-party payments daily limits like 200,000 per day. So based on those daily limits, we can see from here that from a demand side perspective, the banks consider there might be 3 niche markets for payment solutions. They are first, offline payments, including counter payment, credit card payment, and also negotiable instruments, internet banks, and the last one is, I call it smart payments, that include both mobile payments, third-party payments. Then let's analyze which niche markets is most suitable for digital RMB. So the first one, offline payments. The usage of all offline payments is sharply decreasing, and it is also the most HR intensive department in banks. If commercial banks would like to transfer to digital RMB, then probably they have to lay off a lot of employees. I don't think any banks would like to do that, at least in a very short time. And the third reason is that there are currently about 500,000 Chinese who do not use internet at all. So my conclusion would be that commercial banks might not consider the niche market for offline payments would be the best market for digital RMB. And second one, internet banks. Digital RMB and internet banks are used in different scenarios. As we can see from picture I showed before, digital RMB can only be used on smartphones, and internet banks can only use on computers. So when we use internet banks, normally we use it at home or at office in some fixed place. And digital RMB we use basically everywhere. So from a consumer side, the two are used in different scenarios. And most importantly, let's come back to the table I showed before. Let's look at which one? The third column, volume per transaction. Let's look at the average value transaction for online payment, that is 27,000 per transaction. And for mobile and third-party payment, they're like 1,000 or 700. So here we can see that when making large amount payment, consumer prefer internet banks, and when made small amount payment, consumer prefer smart payments. So from consumer side, from a consumer side, digital RMB and internet banks might not be really on the same run market. So commercial banks, I don't think they would consider the niche market for internet banks would be marketed for digital RMB. And the last one, mobile payments and third-party payments. Let's look at this table. So the solid line represents mobile payments, and the line below represents the progress of a third-party payment. So far, mobile payments still is take leading in comparison with third-party payment. However, the increase of third-party payment is much bigger than mobile payment. So that's a competition situation between the two. Then let's look at compare the two payment solutions, mobile payment, third-party payment. Banks using mobile payment, they can benefit from their existing consumer base. And another advantage of mobile payment is nowadays all the Chinese banks just announced that they will charge nothing for mobile payment. And third-party payment, well, they are disadvantaged by they did not have any consumer base, so they have to build up consumer base one step after another. And however, third-party payment has the advantage in more security, because when we use third-party payment, is actually the platform third-party payment hold the transfer until consumer is satisfied with the products. So it's not like when you pay through third-party payment, the other party directly get the payment. So it's more secure for consumers to use third-party payment for online commerce. However, the third-party payment is disadvantaged in the service charge. Nowadays, third-party payment platform charge like 1.1% for consumers. Okay, here. So since mobile payment is under fierce competition from third-party payment, it might be the best market for digital RMB, because commercial banks can use digital RMB to strengthen the position of banks in the smart payment against third-party payments. However, there are still some problems for commercial banks.
I need to ask you to wrap up so that we have some time for questions.
Oh, okay. I'll finish like in 1 minute.
Thank you.
First, there is internal competition between digital RMB and mobile payment, and secondly, there external competition between digital RMB and third-party payment. So the commercial banks must manage those difficulties. And my proposal, just come to my proposal. So the first one regarding narrow bank issues, I think digital RMB should be encouraged to use that as a payment instruments rather than value store instruments. So the solution would be to set the interest of physical RMB higher than that for digital RMB. And the second one, for the competition between digital RMB and third-party payment, it's better to set zero service charge for digital RMB, no matter and without any daily limits. So that might give some edge for digital RMB over third-party payment. And I have wrote an article about this presentation. I mean, if you're interested, you can download this article from SSRN. So that ends my presentation. Thank you very much.
Thank you very much, Professor Ho, for your very interesting presentation and your thorough discussion of the way that the system is being implemented in China. We have a number of questions, and where am I? I'm just trying to find the first question. I had to shut it and I'm opening it again. Okay, we've got a number of questions here. The first one, which I would ask, is to Dr. Smith. And the question is, what types of evidence might be inadmissible in a court but would be available for a tribunal to consider, having regard to the comparison between the two that you've drawn and the fact that you've said the tribunal would be a better forum?
I think that's an excellent question. and not an easy one to answer. First of all, because the tribunal would not be bound by rules of evidence, it means that the threshold for what evidence is presented is likely to be lower. Now, the problem that you've got is, when are you making a well-informed assessment of something that's going to happen in the future but is unknown, as against when are you simply speculating about what is going to happen in the future? And this is not a new problem as far as mergers are concerned. It's always been something of a problem, particularly in situations where there is an expectation that something in the future will change. So, for example, there was a situation where a particular bus merger was being proposed and looked at, and someone said, well, the problem is going to go away because the local government area is going to completely change the structure for providing these services. And the court looked at this and said, well, they may, but we don't have any hard evidence of when they're going to do it or the exact form that it's going to take. And consequently, that particular information was not regarded as part of the assessment process. In terms of the type of evidence that I think is more acceptable to a tribunal than it is to a court, would include things like much more complex economic models. And the reason for that is not simply rules of evidence, although the rules of evidence come into it, but the ability to deal with those models. And judges are essentially generalists in that they may have some form of specialisation in terms of competition law, but presumably in most instances they're also dealing with a range of other sorts of cases. When we look at a tribunal, what we see generally is the composition of that tribunal will include somebody who knows about the business world, somebody who knows about economics. That provides a much better environment for accepting the type of information that might simply be dismissed by the courts as, well, that's a theoretical model, but it really doesn't progress us very far. The other thing that I would flag at this point, and we can come back to it, is that I would expect that we would get more focus on what are the incentives to engage in anti-competitive conduct, and what is there about the merger that provides the ability to go forward with those incentives. And that gets us back into the very the documentation that businesses build up, and with an emphasis on the documents that are built up before the merger itself is actually in play. Thanks.
Thank you very much for your comprehensive answer. I have another question here, which is to the two speakers on CBDC, which would be Professor Ho and myself. How is China's CBDC different from other CBDCs, including from a competition law perspective? Why and what are the implications? I'll give that one over to you, Professor Ho, first up.
Okay, so I will answer the question first, then well, maybe Deborah will add something later. Well, so there are not a lot of countries who have issued CBDC. Well, the only country I know is like Venezuela, who issued like CBDC based on oil. It might be called something like oil coin thing. Well, I think there might be two differences. So the first one, the Chinese digital RMB might not target the international market in the initial period. So in the initial period, the Chinese digital RMB is mainly used for Chinese, And like the CBDC in Venezuela is mainly used as an international currency. It's not for the nationals in Venezuela. And secondly, the CBDC in Venezuela used distributed ledger technology, which makes it completely anonymous. But in China, as I just explained, it's used. It's not used DLT, so it's not completely anonymous. It's called controllable anonymous scheme, which means that basically the central bank maintains like two databases. One database store personal information of the holders. Another database handles the transactions, and the database that store the personal information cannot be accessed by third parties without permission of central banks. The other database that handle transactions can be accessed by third parties like commercial banks or financial institutions. So from the sense of the second sensor, it is anonymous, but in the end, the central bank can still trace all the transactions. So that might be the two differences. We can also compare a little bit the CBDC with Libra, for example. Although Libra is not a centralized currency, it's issued by a group of companies. But the difference between CBDC and Libra is that the CBDC is a legal tender and its value is fixed with physical RMB, and the Libra's value is fixed with a number of currencies like dollar, like the UK pounds, etc. So that's kind of the three difference of CBDC in China with other types of CBDC.
So if I can add to that, I guess they're looking at China from the perspective of what they're doing. It seems to me that China has different motivations to some extent from some other jurisdictions which are developing CBDC. A lot of it is about financial inclusion, because there are very many people in China who don't have bank accounts and may not even have access to the internet, but also, and maybe too far from a bank to get to a bank. So the physical currency is a little difficult too. But the other issue is that, you know, the Chinese government uses monetary policy to control the economy in a way which is more far-reaching than other countries, I believe, do, or than a number of other countries do, and I think that central bank digital currency will be another tool to stop the growth in transactions by third-party providers. Also, China has a specific problem with shadow banking, and the more that the government can control the currency and banking, the better they can address that issue. So I think those are other issues which are on top of what Professor Ho has said. So someone else has asked two questions of Professor Ho, whether he thinks the digital RMB will be a huge success or otherwise, and how the digital RMB will affect the other international currency markets.
Okay, so I will answer the first question, the commercial future of digital RMB. So as I explained in the presentation, I actually cast some doubt on the future of a digital RMB. There are some issues the central banks must plan first before the official launch. So well, there are many countries who have carried out research on digital RMB on CBDC in the last years, and the conclusion it's not really a common conclusion, but most countries consider that CBDC might impose some danger into the current financial system, and the most important danger is that CBDC would disintermediate banks. So in the current financial system, banks are very important because it sits between central banks and financial consumers. It's kind of an agency of the central banks and provides services to consumers. And basically all the financial services offered by banks. But in case of digital RMB, we actually develop a direct link between consumers and central banks. That would put aside commercial banks, which means that the future when digital RMB are used in a much larger scale, as also is planned, that would decrease the lending capacity of banks, which means that in the future banks might find themselves useless. So in the initial stage, commercial banks might not like to boycott. I might use that term, boycott digital RMB, but after a while they might find other ways to decrease the usage of digital RMB. So as long as the central banks might figure out the way to compensate commercial banks or find a new role for commercial banks in the future, I don't think digital RMB will be widely used in China. And secondly, well, in China, basically people always use third-party payments or mobile payments, so that might also give consumers no additional incentive to use digital RMB. Well, because my wife received some digital RMB a red envelope from the government. It's like 50 bucks. So her experience. Sorry, her experience was that the use of digital RMB was exactly the same as using third-party payment. Okay, so that's the answer to the first question, and the second question is about how digital RMB would affect the international currency market. Well, so as I just said, in the initial stage, I don't think digital RMB will be widely used at the international level, but digital RMB might be used by China, as one of the strategy for the Belt and the Road Initiative, because that might be used as a payment for international transactions. Because why I said digital RMB will not be widely used, because the Chinese government have a sort of dilemma over US dollar. So currently the US dollar is kind of the international currency. Well, the Chinese government take a sort of a hate and a love attitude towards the US dollar. So on the one hand, the Chinese government is kind of the big shareholder of the US dollar. So it is not the intention of the Chinese government to see the US dollar will lose its dominance in international market. However, on the other hand, so in the last years, there is an ongoing trade war between China and the United States. So the Chinese government must find a way to stay a little bit away from the US dollar. So So in the future, I think the Chinese government will gradually decrease its dependence on US dollar. However, that will not come anytime soon. So digital RMB will be used as international currency, I think only in a very small scale or experimental scale. I don't think it will affect the dominance of US dollar anytime soon. Okay, so that's my answer to the second question.
Thank you. And one might see ultimately see international contracts under initiatives like Belt and Road with conditions which require payment or of funds one way or the other in digital, in CBDCs, it seems to me, longer term. But as you've rightly pointed out, China has a vested interest in not devaluing US dollars too soon because of its substantial holdings of them. Someone else has asked whether, has said CBDC is backed by government and may receive preferential treatment compared to other virtual currency, such as Bitcoin, which might even be prohibited in some jurisdictions, and my understanding is it's prohibited in China. There is a question of whether treatment given to CBDC is discrimination towards other virtual currency or not. In this regard, the WTO GATS prohibits discriminatory treatment for the same services if it is given under like circumstances. What trade policy do we need to consider in relation to this situation? I mean, my first comment on that, and it'd be subject to the other participants, would be whether in fact they are the same thing. It's whether they are the same services, because one is a currency backed by government and redeemable from the central bank, and the other is a private operation which performs a similar function. But I'd be interested in your comments on that, Professor Ho.
Okay, so my comments is that so first, I mean, the WTO GATS prohibits discriminatory treatment. However, the WTO prohibits discriminatory treatment in service only as a principle. So its implementation still depends on the negotiation between member states. So well, putting a simple word, this principle can only be implemented when somebody promised that they will respect that principle. If there is no such a treaty between member states, so well, member states are still allowed to discriminate in services. So services and goods are different. I mean, goods, you cannot apply discriminatory conditions for goods, but it's possible to apply discriminatory treatments for services. And and my second comment is the same as Deborah. So first, I mean, well, currency might not be considered as a service. It's a sovereignty of the member. It's sovereignty of a country. So normally, I mean, it's not well. So far as I know, it's basically impossible to use a foreign currency in another country. I mean, so the like RMB is a legal tender. I mean, it's protected by law. Nobody can reject RMB in China. But I mean, if you use US dollar in China, I mean, it's not like RMB, right? So basically they are not comparable. Okay, that's my comments.
Thank you. I don't know if you have any comments on any of that, Rhonda. Okay. Well, look, I think we might wrap up our session there. I just wanted to, in terms of the dynamic nature of markets that we're talking about, I just wanted to relate to you my experiences in visiting China. I've been going to China for the last 15 years. My experience in China in August 2019, which was my last visit when I caught up with Professor Ho, no one took physical RMB, and I couldn't get a rideshare driver who would take physical money or my credit cards. I had to end up giving my money to the concierge at the hotel I was staying at, who organised a rideshare driver for me, and he paid him by his app. That was the only way I could get to the airport when I was leaving. And that was in marked distinction to my numerous other visits. I think I've been to China 40 times. My numerous other visits, and even as little as in the May of the same year, I had no problems with anything. Only some stores would take my credit cards. So that was a remarkable turnaround from earlier that year, and it's a real testament to the way in which these dynamic markets are moving, with implications both for CBDCs and monetary policy, and also for the areas that Rhonda was talking about, because of course she was talking about mergers in these dynamic areas. So with that, I'd like to thank our speakers, Dr. Rhonda Smith and Professor Liyang Ho. And I would also like to thank all of you for attending our CBDC event and for listening, and also for your great questions. And we hope that you will join with us in our next session, which we will notify you about, which is on in a few weeks. So thank you very much, and thank you to our administrators for organising this so seamlessly. So good evening, everyone.